Hi, my name is Susan Colley, and welcome to You're Not Alone Surviving Your Child's Disability. As a parent, obtaining legal guardianship for your child with a disability is a fundamental issue for consideration. Joining us today to discuss the meaning of guardianship and what it entails is attorney Barbara Jackins with the Special Needs Group of Massachusetts and Dr. James Karen, licensed psychologist and co-director of the Competency Consultation Group in Lexington, Mass. Hi, how are you today?
Very well.
Good. I'm glad to have you here. First of all, can you explain what guardianship is and what is its purpose? Would you like to start?
Well,
Jim?
under Massachusetts law, when someone turns 18, they're considered to be competent to make their own decisions. Guardianship provides a mechanism whereby the parents can continue to help the child by making decisions on their behalf and basically continuing in a similar role that they had when the child was younger.
So Barbara, could you tell me at what age do you think that you should start to consider guardianship for your child?
Sure, Susan. I think at the latest, when the child is 17, parents want to be seriously thinking about guardianship because, as Jim mentioned, when the child is 18, he or she is presumed competent to make legal decisions on their own. So that means, let's say they have, the person has a serious medical condition.
Mm-hmm.
When they're a child, naturally, we parents can sign for medical care or decide anything that the
Right.
child needs. But when the child is 18, they're presumed able to make medical decisions on their own. So a doctor might be reluctant to treat them because, as we know, when you go in for an operation or medical procedure, you have to sign saying that you understand the risks and benefits of the procedure. And
Mm-hmm.
if a doctor thinks that their patient can't understand the risks, they might not
Right.
want to treat them, and they might say to the parent, you need to get guardianship. So it's
Right.
good to be proactive and plan for that rather than just let it happen or have to deal with an emergency.
Yeah. Now, is that prevalent for, say, for instance, if you're 18 and you're in like a special education program, and you are in there till you're 22, that gap from 18 to 22 still has to be covered by a guardianship?
It doesn't necessarily. It depends on the person. Sometimes, well, all the school departments ask who will be making decisions, and they want the child and the parent to sign, so the child can delegate to the parent, but they could say, you know, I don't want my parent involved, and
Mm-hmm.
some 18-year-olds might be ready to be all done school, and they're happy to sign paperwork ending their education, and you don't want that to happen because
okay.
you'd be forfeiting 4 years of free appropriate public education. So that's a good example of when a parent would have to intervene.
Right.
But the eligibility for school services is different from being considered competent to make decisions under the law. So even though someone can stay in school until 22,
Correct.
if they're not really able to make informed decisions, they may need a guardian.
Okay. Now, how can parents decide whether or not it's necessary to seek guardianship for their child with a disability?
Want to answer that,
Jim?
Jim?
Do you want to take that?
Well, parents know their child very well, and we know that parents really are concerned about maximizing the child's areas of independence throughout their lifespan.
Right, but what happens if a child, for instance, can't make any decisions for themselves? I mean, just because of the nature of the disability, like a child with autism or a child who has a severe mental illness or something like that.
Yes, in those instances, parents would recognize that the child can express certain areas of preference, but may not really be able to make any complex decisions that take into account weighing both sides of an issue, anticipating consequences, etc. So in those situations, parents would want to consider guardianship or some way of being involved in the decision-making process.
Right. How much can a child be involved? If a parent is a guardian, how much can a child get involved with their own care?
Mm-hmm.
Do you know? I mean, Barbara, do you have any idea?
Well,
how
of
that
course,
would
it
work?
depends on the child. And sometimes I hear people, and this can come from attorneys or parents or educators, they say, guardianship can be bad because it takes away the person's rights, and it takes away their ability to make all decisions. But clearly that's not true, because with guardianship, the guardian is just making major decisions for the person. So it's going to be medical decisions, educational decisions, signing paperwork with agencies that they're involved with, like DDS or DMH. But, but the person continues to make their decisions about their day-to-day, like what am I going to wear, what am I going to eat,
Right.
Who am I going to be friends with, what am I going to watch on TV, what kind of music do I want, that kind of thing.
Right.
Guardianship
Okay.
does not affect that. And of course, as parents, if we're the guardians, we can't make those choices for our
Right.
child, even if we wanted to. It would just be unworkable.
Right.
And also, as a parent, the parent would take into account what they know about the child's preferences, even in making larger decisions, and would try to guide the child to explore as much as they can what they would prefer. For example, if they were considering housing options, the parent would not simply impose their own view, but would take into account what the child might prefer.
Okay. What about limited guardianship? How does that work? Barbara?
Well, there are a couple of ways of looking at limited guardianship depending on who you talk to. Some parents or some people say that limited guardianship means that the guardian just makes decisions in one major area, like, for example, a medical guardian. And so the only decisions that the guardian makes are related to medical care. And then the person makes their own decisions for education, living arrangements, dealing with state agencies and that kind of thing. So that's one way of looking at limited guardianship. Another way of looking at limited guardianship is that the guardian is going to make all those types of decisions, but the person is going to decide, like I was saying before, what to wear, what to eat,
Right.
who to have, be friends with, whether they can use the internet unsupervised, that kind of thing. So the guardian would be limited and would not cover those specific areas, and that would be written right into the court paperwork.
Okay. Speaking of courts, how do you prove to a court that a child needs a guardian?
Well, I'll
Jim?
Yeah.
Or
Yeah, go
would
ahead.
you like
Talk about
to?
that.
Doesn't matter.
Well, in order to apply for guardianship, there has to be a certification that the individual does have an intellectual disability that would interfere with making complex decisions. So the process that is in place is called a clinical team report. The clinical team report is an evaluation by a licensed psychologist, a licensed independent clinical social worker, and by a physician. And each of those three professionals has to do an evaluation of the child's capacities and needs.
Now, does that happen during an IEP meeting, or
That-
is that something that a parent demands, is a clinical team report?
I think it's separate from the school process, even
Okay.
though as part of the IEP process, it is likely that the school psychologist would have done an intellectual tests, an adult intelligence measurement. And that is one of the requirements on the clinical team report. The court does require testing to be done that certifies that the score indicates an intellectual disability.
Okay.
I'd also just interject too that the three parts that Jim just described are necessary for people with intellectual disability, which we used to call mental retardation. But if the person has mental illness, let's say, or high functioning autism, and doesn't meet the definition for intellectual disability, then there can be just one evaluation done by, can be a licensed psychologist like Jim or a physician.
Or a nurse, psychiatric nurse specialist.
That's right.
Okay. So what are some of the alternatives to guardianship? Say, for instance, you don't want a full guardianship, or or you don't want guardianship at all. You just want to make sure that the child is being protected in some manner from, decisions. Jim?
Well, this is something probably Barbara could speak to a little bit better. There are some other instruments that a child can voluntarily agree to, such as a healthcare proxy or power of attorney, but they do have some, they're much less comprehensive, and also the child could revoke those permissions at any time. But perhaps you could say something
Sure.
about that.
Well, for medical decision making, let's say that the parent doesn't want to be the guardian, but yet they want to be involved in the child's medical care,
Right.
which is very sensible, because when the child is 18, as probably you and a lot of parents know, this idea of medical privacy comes into play. So anyone treating a medical insurance provider or a physician or anyone treating the child is not supposed to disclose their patient's private medical information without their written consent.
Okay.
So the child has to give consent, and they may not want to do that. So, so that's why it's necessary to have them sign. Could be a medical release.
Who signs, the parent?
No, the child has
the
to sign.
child
When they're
has to
18, the 18, well, now an adult has to sign.
And that's giving permission for the doctor to share information with the parent.
I see.
Right.
So what is that called? A healthcare proxy, or is it
Well, we
something
do
different?
have healthcare proxies, but that would be called a medical release,
I
or
see,
perhaps
okay.
a permission to share form. Every doctor's office will have one for people to sign. Now, healthcare proxy is a little different.
Okay.
A healthcare proxy kicks in if there's a medical emergency and the person can't communicate with their doctor.
Okay.
That's something that all of us should have,
Have.
or every responsible adult should have, in case you're injured or in an accident, and you can't communicate with your care providers. So the person you've named to be your agent can step in and take over and make decisions for you. But it's not for routine, day-to-day medical decisions.
Okay.
So this actually brings up just another example of why the child could be at risk of harm without the appointment of a guardian. And that is, again, that the physician might not be able to communicate with the parent, and also, unless it were an emergency, the physician might not perform a medical procedure if they feel that the child doesn't really understand the benefits and the risks of it.
I see. Okay.
I should say a little bit more about the actual interview process for the clinical team report, because we sort of went by that quickly. Is that okay?
That's,
Yeah.
So
sure.
what I wanted to explain is that there are basically 3 areas of competence that we're interested in, and that is whether the child can make decisions about medical affairs, whether they can manage their own finances and use of money, and also whether they can make other major life decisions independently. So in the interview, we want to explore the child's understanding of medical issues. If they are taking medication, we'd like to know if they understand the purpose of the medication, what is the dosage, what would be any consequences of forgetting to take the medicine or of taking too much, are they aware of side effects, how would they communicate with their physician if they felt that they needed a change in medication. So these are, it's not simply whether the person would agree or not agree with the doctor's recommendations, but how well can they process that information and understand the purpose of the doctor's recommendations.
Okay, and that's the same basic principle for financially and for educational aid
That's
as
right.
well.
For example, the individual may be able to make very small transactions, for example, to go into a store and order some food or some small item. They may be able to handle that level of decision making about money, but if they actually had to budget to, say, pay for independent living, like budgeting for an apartment, knowing what the telephone would cost, the cable, the utilities, and would they have enough money to handle that, those kinds of decisions might be beyond their capacity to understand.
Ah, okay. Could you explain what the term Rogers guardianship means?
Yes. Rogers was our court case here in Massachusetts that dealt with antipsychotic medication.
Okay.
So if a person who's going to be placed under guardianship takes any antipsychotic medication, which would be Risperdal, Seroquel, others, Jim?
Yeah, Zyprexa, Abilify,
Right.
commonly used now.
So if a person takes any antipsychotic, their guardianship becomes a little more involved because a judge has to make the decision about whether the antipsychotic medication is benefiting them and if the dosage is proper and whether the alternatives that are being proposed are make sense for the person. So the court appoints a guardian, appoints an attorney to represent the person who's going to be placed under guardianship, and some additional medical documentation is needed from the prescribing physician.
Okay.
Yes, the Rogers procedure began when the antipsychotic medications used were very, very strong and could cause irreversible side effects. Those are medicines like stelazine and thorazine and Haldol, which
Yeah.
are still in use. The current medications are much milder, but because they come under the category of antipsychotics, that protection is still required.
Now let's get this straight though. The Rogers, now it's an attorney in addition to the guardianship?
Yes, the attorney represents the person with a disability.
I see.
So they have their own attorney.
Oh, I didn't know that.
And the attorney stays with them. At the guardianship hearing, the judge will sign a treatment plan for medication, and that remains in effect for 1 year,
Okay.
unless something needs to be changed that's not included on the treatment plan, and then it's reviewed every year in court. And so the attorney stays with the disabled person throughout the process.
I didn't know that. Anyway, what are the guardian's actual responsibilities? Once they become guardian, what are they reasonably expected to do?
Very good question. Some parents become a little bit intimidated by the title of being the guardian and their responsibilities.
Right.
The guardian is not responsible for actually providing direct care. The guardian does not have to provide for the financial needs or the direct care needs of the young person. The guardian makes legal decisions as required. They would be overseeing the care.
Okay.
And that's another.
Who then makes these decisions? The actual client or the child?
Well, for example, decisions about what kind of program, whether it's an educational program or residential program, those decisions would be made by the guardian. The guardian would certainly consult their child about preferences, but the ultimate decision would be made by the guardian.
Sure.
Okay.
I'd point out too that the guardian isn't responsible for the person's behavior. So This
Right.
can be a concern sometimes if a sibling, let's say, is asked to be a guardian for a disabled brother or sister, and their question, is, well, am I financially responsible for them? Or let's say that they hurt somebody or damage their property, do I have to pay out of my own assets? And the answer is no. Our Massachusetts law specifically protects guardians from bad acts or financial irresponsibility of the person that they have agreed to be guardian for. So they're protected.
They are responsible for filing an annual report
Yes.
about the services that their child is receiving. And it has to be filed, I believe, 60 days after they're appointed as guardian, and then once a year. And it's a simple form that they can fill out, and actually, if they just keep a copy on file, make some minor revisions each year. So it's not a huge burden.
Oh, okay. So we touched on the financial aspect of it. This would be like a conservator. And what is a conservator in relation to a guardian? I mean, what is the difference?
Well, a guardian makes personal decisions. So, again, their medical care, their living arrangements, their education, that kind of thing. A conservator is strictly involved with their money.
Okay.
Now, conservatorship is not very common here in Massachusetts, at least for parents helping their children, because it's very complicated, because you have to go through the court and you have to report to the court every year. So it's quite burdensome. So, but that's all right, because there are so many easy ways to help a son or daughter manage their money. One is that if they get any benefits from the government, like SSI or Social Security disability, the parent can become their representative payee for benefits. So that means that they can receive the check directly in their bank account and use it for their child. So that's a nice, easy way to manage government benefits. If the person has a job, they can have a joint bank account with them so that the money can come into the bank account and they can help them manage and spend it. Any money that parents leave to their disabled child, it should be left to a special needs trust. So a trustee that they name, can manage that money. So there's really no reason for a person with a disability to have a great deal of money in their own name that would require someone going to court and becoming a conservator to help them with it.
Okay.
As long as they've planned properly.
Yes, that's right.
To set up the special needs trust.
Yes.
Right.
And for example, to make sure that the disabled child's name is not on the title to the house. They might become, the proceeds from the sale of a house might be for their benefit, but they shouldn't be named, for example, as an owner of the property, because that would create a lot of complications.
Or,
I see.
and they
Okay.
shouldn't be a direct beneficiary of life insurance or probably a retirement account either. All of those assets should be directed into a special needs trust for them.
Okay. Who takes care of the trust? I mean,
Well,
did I
whoever is
miss that?
named.
Anyone who's named?
Can be
That would
a
be a trustee.
sibling or professional,
Okay.
or both.
Now, what does getting a guardianship cost? And can a parent handle guardianship alone without an attorney?
Well, there are different costs involved. I can speak to the cost of getting a clinical team report. In some cases, the school psychologist who knows the child well may be able to complete the report if they're familiar with that kind of evaluation. For our own team, I work with a clinical social worker, and we go together to the family's home or to the school to do our part of the evaluation. And we find that it usually takes 4 to 5 hours between meeting with the child, meeting with the parents, reviewing records, interviewing staff or teachers who work with the child. So we bill sort of a regular clinical rate for 4 to 5 hours.
Okay.
And then the attorney's costs, you could mention something about that.
Yeah,
Okay.
there are no court filing fees. Well,
Oh,
there's a
there isn't.
$15 fee.
Oh.
But
Oh,
other than that, there are no court filing fees. And
Okay.
then, so the attorney's fees, I would say, for a guardianship that is not Rogers and is not
Okay.
contested by anyone, because the child might contest, or sometimes if the parents are divorced, and the mother, it's usually the mother that wants to not involve the child's father in the guardianship, the father might contest it. So,
I see.
but if the guardianship is not contested and not a Rogers, probably the fee is from $1,500 to $3,000, I would say,
Okay.
depending. Rogers guardianships, in my experience, can be from $2,000 to $5,000,
Okay.
depending.
Do you feel in your experience a parent can handle it, handle all the paperwork and everything that entails getting a guardianship?
I think the Rogers guardianship is very difficult to do
Okay.
without an attorney. However, there are some options. If the parent feels that they can't handle the full cost of a private attorney, all of the probate courts have a limited representation project where attorneys agree to do some, but not all of the guardianship. So they might do the pleadings, let's say, but not go to court.
I see, okay.
So
they
can-
might do half, you know, and
So-
cut down the cost.
Or they might,
Exactly.
they might review the paperwork to see if it's completed properly.
Yes.
Okay.
And for some older folks, if they're served by DDS, sometimes DDS will handle the guardianship.
Okay.
And it may take, it may take a while, but that can be an option too.
Okay.
Which brings to mind there is a time limit on the clinical team report. It has to be, the court filing has to be within 180 days of the clinical team report. And the purpose for that is to make sure that the evaluation is really current. It's not something that was just done years ago and kept around until the family wanted to apply.
Okay. So what happens if your disabled son or daughter improves their functioning enough so that they no longer need a full guardianship?
I've had that happen. You can get a certificate from a doctor stating that they can now make decisions on their own, and you can file that in court and the guardianship can be dismissed.
Okay, or can they go from a full guardianship to like a partial guardianship?
Yes.
Just depending on how, you know.
Yes,
the
they
child
can do
is
that too.
functioning.
And actually, when we do our evaluations, we assume that an 18-year-old or 17-year-old is still learning new skills. We often write in our report that the question of guardianship should be revisited within 5 to 10 years.
So, okay.
Partly
That's a
because
good
of the
idea.
acquisition of new skills, but also part of the urgent need for guardianship is when the young person is making the transition from living at home with educational services into the adult world. And once that transition has been made, it could be that there are very stable supports in place and guardianship is not needed at that point.
Okay. Is there anything that stipulates or any kind of way that you have an emergency guardianship?
Yes.
If you need one?
Sure. Guardianship can take a while from the time to get to a judge from the time you file. But if there's a medical emergency going on, the parents can get an emergency temporary guardianship that's valid for 90 days.
Now how quickly can they get that?
Well, if they have their documentation from their psychologist, they could get it the same day
Okay,
if they need it.
that's great.
Mhm.
Well, I thank you, Barbara and Jim, for this informative discussion on guardianship. So I hope that you enjoyed the show, and that you tune in again for You're Not Alone, Surviving Your Child's Disability.